Earlier this week, potential jurors in Washington, D.C. in the case of United States of America versus Donald J. Trump received preliminary questionnaires about their potential availability for a trial beginning on March 4th. And today, Donald Trump's lawyers filed a motion to block any more preliminary steps in jury selection in that case and to block everything else in that case. Donald Trump's lawyers filed a motion this afternoon to request, quote, the automatic stay of all district court proceedings in this case pending the final resolution of Donald Trump's recently filed appeal from the court's December 1st, 2023 rulings on presidential immunity and double jeopardy. Last Friday, Judge Tanya Chutkan issued a 44-page ruling denying Donald Trump's motion that he is completely immune from any criminal charges for anything that he may have done while he was president of the United States, and that putting him through a criminal trial for his activities leading up to and on January 6th would be double jeopardy after he was impeached by the House of Representatives for the same activity and went to trial in the United States Senate for the same activity, a trial in which a majority of the Senate voted to convict Donald Trump, but not the two-thirds majority required by the Constitution to convict a president in a Senate impeachment trial. A participant in that trial will be joining us later. In the Trump motion filed this afternoon, the Trump criminal defense lawyers specifically asked the court, quote, to stay all proceedings in this matter pending appeal, including, but not limited to, pretrial motions, defense disclosures relating to trial defenses and evidence, Classified Information Procedures Act hearings, and jury selection. Donald Trump's criminal defense lawyers use that classic phrase that so often appears in such motions at the beginning, saying that defendant Trump respectfully submits this motion. That motion is being submitted to a judge who Donald Trump has publicly attacked. The Trump criminal defense lawyers use that phrase, respectfully submits, to a judge who they have said should be attacked by Donald Trump. Donald Trump and his criminal defense lawyers do not respectfully submit anything. Donald Trump's criminal defense lawyers have professionally disgraced themselves time and time again by disgracefully employing Donald Trump's tactics as their own. The founders of the American government believed in an American government by gentlemen, for gentlemen, all of whom, of course, had to be white gentlemen. They were incapable of imagining the expansion of the right to vote in America to reach people who were not like them, people who do not think and behave like gentlemen of the 18th century. And so it was inconceivable to them that voters would ever elect someone like Donald Trump, president of the United States, and nothing in their design of government was built sturdily enough to defend against the assault that Donald Trump has already mounted on this government. The latest branch of the government on the verge of being humiliated by Donald Trump is the judiciary. Donald Trump publicly attacks judges in a way that no one ever has before. And no judge attacked by Donald Trump knows what to do about it or how to stop it. Each judge attacked by Donald Trump sits powerless in the face of the attacks. No one in the legal community thought that was possible before Donald Trump did it. No one noticed that there was no law against publicly attacking and threatening judges handling your case until Donald Trump did it. And that's not the way Donald Trump will ultimately humiliate the judiciary. It will be worse than that. They will do it to themselves. The federal judiciary will do it to themselves if they continue to approach Trump criminal litigation as business as usual. The Circuit Court of Appeals in Washington, D.C. has been considering Donald Trump's appeal of a very limited gag order on Donald Trump issued by Judge Chutkan for 5 weeks now. And whenever they issue their opinion on that, Donald Trump is very likely to appeal it to the United States Supreme Court. When will the appeals court, which seemed during the oral argument in the case to unanimously agree that there should be some form of a gag order, finally issue their opinion? We have no idea. There is no deadline on their proceedings. The same appeals court has taken 2 years to issue some opinions. 2 months is considered fast. The United States Supreme Court can take the better part of a year at the final stage of such appeals, and it doesn't have to be this way. The courts have made it this way. The appeals courts and the Supreme Court have chosen to move as slowly as they do. In some cases, it is understandable that appeals take years because they are relatively low priority items on a very crowded docket for judges that have many appeals to decide and many opinions to write. In the cases of criminal defendant Donald J. Trump, all of those other cases on the docket should just be pushed aside. The appeals court should be working on nothing else until they reach that decision. Same thing with the United States Supreme Court, and they know how to do this, but they don't do it. And no one can make them do it. The oral argument on the appeal of Judge Chutkan's gag order took place 2.5 weeks ago. There is no justifiable reason why that opinion has not already been issued. You know how long it took the United States Supreme Court to rule on a case that decided who would be the next president of the United States? It was a novel case. Nothing like Bush v. Gore had ever come to the United States Supreme Court. None of the judges had ever considered the issues like the issues presented to them in that case by the very able lawyers who were given unprecedented amounts of time to argue their case, make their oral arguments to the United States Supreme Court, which were the very first Supreme Court oral arguments in history that were allowed to be broadcast live on radio, because the Supreme Court apparently considered that to be the most important arguments in the history of the Supreme Court. 1 day. It took the Supreme Court exactly 1 day after those oral arguments to issue their decision in what they were, in effect, declaring was the most important case that they ever heard. Supreme Court scheduled and conducted those arguments. The way they did that, the way they did it quickly, they were in effect declaring this is the most important thing we've ever done. And after what the Supreme Court was essentially declaring was the most important argument they ever heard, they took exactly 1 day to decide the case and issue their opinion, making George W. Bush president of the United States. They know how to do it when they want to do it. The question Donald Trump is now presenting to the judiciary is, will they do it? Will they do the right thing? We have seen some very fast appeals of the horrendous rulings made by a Trump-appointed judge in Florida who has been handling the criminal case Jack Smith has brought against Donald Trump there on espionage charges. The 11th Circuit Court of Appeals has very quickly issued written opinions overruling that judge. But the time that the D.C. Circuit Court of Appeals is now taking simply on a gag order is a very, very bad sign for how they will handle the other appeals that Donald Trump now respectfully submits to them. Donald Trump is presenting the appeals court with novel and important issues, but they are not complex issues. The appeals court should be able to expedite the appeal and issue an opinion within days of the oral argument in the case. And then the United States Supreme Court should move very quickly on Donald Trump's appeal to the United States Supreme Court of that decision, if there is one. Donald Trump is testing these appeals court, including the Supreme Court, and he is betting that, like the trial judges currently being attacked by Donald Trump, the federal appeals court in Washington, D.C., and the United States Supreme Court do not know how to handle Donald Trump.